Okay, welcome everyone. Thanks for joining us today. We're here to talk about data protection laws and all of the, some nuanced and weird and wonderful things around data protection laws. So as we all know, data protection laws are evolving at an unprecedented pace, impacting organizations of all sizes, industries, all across the world. And to thrive, businesses not only need to comply with these regulations, but harness them as a strategic advantage. So when it comes to the penalties and non-compliance penalties associated with these, organizations not only face hefty fines, they can also sustain reputational damages too. So today, to discuss navigating these complex data protection laws and some of these parts of them, I'm joined by two legal experts. We got Sarah Jarman, VP of Legal and Group DPO at Amplify, and Christy Goldsmith, who is Data Protection, Privacy and Cybersecurity Partner at Spencer West LLP. Before we get started, I'd like to say, while we give an overview on industry regulations and complexities behind them, we suggest each business should obviously seek individual advice when it comes to complying with the regulations relevant to their organization. So thank you for joining me, Sarah and Christy. We were just before this, Christy's camera wasn't working, so we wanted to make it clear Christy isn't so obsessed with data protection with her camera on. We've just got a few technical difficulties. But Christy, Sarah, it's great to have you both here with me today.
Thank you.
Okay, so let's jump right in because we've got a big audience and I know there's probably some people are waiting for us to get started. As always, if you've got questions to the audience, please do put them in live. We've already got some questions ready to go. So we're going to talk about data protection laws and navigating these complex regulations. And then at the end, we're going to talk through some of the questions that accumulate throughout today's talk. Okay, so topic one is a very, very broad one. So I think we're going to have to do a good job at containing this because we've only got 45 minutes. So navigating complex regulations. Let's kick off with the regulations that lots of organizations must adhere to. What we have seen with Matomic is a lot of our customers come to us to help them comply with regulations around the world, such as GDPR or HIPAA or PCI DSS and many, many others. What Matomic does, just for the audience sake, and obviously me, Sarah and Christy have talked about this, Matomic helps companies minimize the amount of sensitive data they have, particularly in SaaS applications. So like Slack, Microsoft Teams, Google Drive, Box, and so on, so that this data doesn't go stale and making sure that these applications are clean without the risk of just data that's not needed anymore being breached or non-compliant and so on. So let's start by talking about GDPR in the UK and the EU. Christy, could you talk about some of the important aspects of GDPR and how it relates to personal and sensitive data? I'm throwing over a very big question, but we'd love to get your take on it.
Yes, thanks for that. Sorry about the camera. I actually did put a nice top on. Anyways, so the GDPR came into force in the EU in 2018. So, but after Brexit, the UK government rolled all the EU legislation into UK law, which then resulted in the UK GDPR. So organizations have to contend with both the UK GDPR, and for those that are dealing with processing the data of people in the EU, they also have to comply with the EU GDPR. The next wrinkle for the UK is the government has the Data Protection and Digital Information Bill, which is at the committee stage in the House of Lords, and it's going to shake things up a little bit. So the date for the next stage, which is the report stage, is yet to be confirmed. So whether this passes this year or not is another one of these kind of watch this space things, but that will be another change for organizations to contend with, because it will change the way the UK organizations have to deal with data. But like I said, the ones who are working in the EU still have to comply with the EU GDPR, right? So just as an overview, the GDPR as a whole, both UK and EU, sets out principles that organizations have to comply with, like data minimization being one of those. It also deals with rights for data subjects, legal basis for processing, requirements for privacy notices, among other things. and special category data, which is data revealing racial, ethnic origin, political opinions, religious, philosophical belief, trade union membership, genetic data, biometric data, has its own requirements for processing. So in addition to all of that, it also governs the transfer of personal data outside of the UK to ensure adequate protection for those individuals' data that's being transferred outside. So the regulations are complicated. Obviously, there's not just the GDPR that UK organizations have to contend with. There's the Data Protection Act as well, which supplements the GDPR. Then there's the Privacy Electronic Communications regulations. So essentially, it's quite a complex show out there that they have to deal with.
And Christy, probably a lot of the audience know, and I certainly know myself, but it's not, these data protection laws, they're not clear-cut tick boxes, are they? They're quite complicated to understand. They're open to how you sort of perceive them, and I think each organization probably takes roughly its own approach to how they go about compliance with these complicated regulations.
That's absolutely correct. So when the GDPR was passed, it had to apply in 28 member states, right? And it took them 6 years to pass it. That's like trying to get 28 people to agree on where to go for lunch. It was a really long and tough road to travel. So it has things like, you must have the appropriate technical and organizational measures for your organization, but there's no way it can tell you what you actually have to have. So that's the kind of vagueness that it has. But because technology is so fast moving, it couldn't be technology specific, because if it was, it would be out of date by the time they negotiated it to when it was actually passed. So it is kind of vague in that regard.
That's a fantastic point, right? We're seeing, for example, Gen AI tools. There was nothing in GDPR that talk explicitly about how to relate the GDPR and data protection to Gen AI. So technology is moving at such a fast rate. It's sort of constantly having to apply it to these new environments. Sarah, just switching gears a little bit. So your background's in international law. We see a lot of our US healthcare companies have a big focus on things like HIPAA, of course. Are there any regulations people should be paying attention to from a global perspective? Obviously, GDPR is also a global perspective too. What are the challenges of these in terms of sensitive data sharing?
There's lots to answer your original question to be aware of. And you've also then got the added challenge of, so typically it would be sensitive data. I know we've got special category data and the different sort of terms. That's one example. And then you've got the different definitions of what that constitutes. So HIPAA is obviously based in the US. At the moment, it's referred to commonly as a patchwork quilt. So you've got 18 states at the moment have active bills at the moment, and 15 have signed different laws, but of course not all are quite enforced. And each of these have different definitions of sensitive data. So for example, a credit or debit number would be considered sensitive in California, but not say in Colorado. Or a precise geolocation in Connecticut is sensitive, but not in Virginia. So the difference just within one country can be quite great. You obviously see a slight sort of reflection of this in places like Canada as well. Although they've got PIPEDA, if you've got substantially similar laws like in BC or Quebec, then it can vary again. And then, of course, you've got, as you've just alluded to, your general global approach. So it's a very trendy thing at the moment to be introducing new data protection laws, introducing new AI regulations. And typically you will see either a risk-based approach or a rights-based approach. So obviously the EU taking more of a risk-based approach, China taking more of a rights-based approach, but equally on data protection. So you've got their sensitive personal information, once leaked or illegally used, may easily lead to infringement of a natural person's dignity or endanger personal safety or property of a person. So it's very, again, quite wide in what that could be. But then equally, you've got somewhere like Brazil, for example, that mirrors the GDPR, but it would be a dangerous thing to say it's the same. same for similar to what was discussed just now in terms of racial or ethnic origin, religious belief, political opinion, trade union, genetic or biometric data. And obviously in the US, you've got BIPA and things like that too. So the extent of what these mean is almost deliberately broad. And I guess that makes it a real challenge then for companies to abide by. I mean, India actually doesn't even go that far. It just says digital personal data. And then, you know, it's up to the company to try and prove compliance with that. So a real challenging sort of sphere.
And so you talk about the different approaches from like a country point of view, but also over time. So GDPR, for example, what is now the EU GDPR and it's now branched into the UK GDPR2, went live, so to speak, in 2018, if I'm correct. So
yes, well done.
Thank you. So it's been 6 years or so. Sarah, you must see different companies depending on what factor are you seeing a convergence in the way that companies are approaching these complicated regulations, or are you seeing a divergence or the same, which is each company's got its own approach to tackling these complicated regulations?
So it does depend on size, because I think one of the biggest complaints we've heard from industries generally is that the cost of doing business or the cost of compliance is so high if you look at these on the granular level. So typically what I generally advise is that you take the most onerous and then operate at the principles. And as was mentioned earlier, again, when you operate then at the principle, you can tailor, but you can then defend. And so you often see throughout the world in these different sort of privacy approaches. And, you know, now we're also seeing, I'm very, very excited for the American Privacy Rights Act just being sort of released. And again, focusing on things like data minimization, data transparency, data security obviously being a massive part of that. So you do then see the trends, and it might not be on the exact granular level, but that's a great coping mechanism, if you like, for some of these businesses that don't have the armies of, you know, lawyers or security professionals, etc. So they can either look to establish that and then a company that is specialist in whatever area it is, you know, whether that's outsourcing DPO, outsourcing your sort of security capabilities, and then look to exact that through your principles that you've then established through your internal governance.
That's amazing. Well, firstly, I'm very happy to be speaking to one, maybe two people that are excited about new acts coming live. So that's great. We've got a great forum.
We're in the minority, I think.
Yeah.
Yes, I think so.
Yeah. So hopefully not too many people have dropped out so far. Christy, coming to you, similar question. How have you seen broadly the approach change and evolve over particularly the last 6 years? Because we did start talking about GDPR, but are you seeing that convergence in terms of strategies and approaches, or a divergence, or something different?
I have seen at the beginning when before it came, the GDPR came in 2018. There was a huge rush for compliance because companies literally thought that the ICO was going to be standing on the doorstep on Monday, ready to do like an Ofsted inspection. And so everybody was rushing to comply. They all thought the sky was going to fall in. But after that initial rush to compliance, it was more of an understanding of why the application of the principles and the regulations was actually a good thing for a business, where businesses and organizations were going, yeah, people want us to look after the data. People want to know what we're doing with their data. They want transparency. You know, they want accuracy. They want access. So it became not a rush to compliance after that, but a more in-depth understanding of how the law applies to them and what it means to their employees, to their clients, to their customers.
Very interesting. Yeah, so it seems to be going back, because Sarah, you mentioned this as well, thinking, you know, broadly about these principles, not just principles of GDPR, but principles in general. and applying those on a more fundamental level than maybe a surface level tick the box compliance so the ICO don't come and fine you, right? Talking about principles, I want to talk about, we recently released a report on how financial organizations handle data security. We found 86% of data in Google Drive, which is obviously a very commonly used SaaS application for document storage. 86% of the data and the sensitive data in there, which is a combination of personal data and other things, hasn't been updated in 90 days. So it hasn't been touched, hasn't been viewed, hasn't been updated in 90 days. Obviously, when it comes to a principle of GDPR like data minimization, it's quite alarming. If a company was breached, this data would be ripe for the picking, and also it doesn't really need to be there anymore anyway, because I assume it's not being used. What are the, is there any legal ramifications that people need to think about when it comes to technology and fast moving applications like SaaS, where typically you do something, it's useful for a day or two, a week, maybe a month, but then time moves on and whatever it might be, that document you uploaded 2 months ago is no longer relevant to your organization. How do you both see people approaching this? And I'm talking about data minimization here.
So I think the first thing is also then the other key principle of transparency. So you need to know what data you have in the first place to know how to manage it. And then, as I'm sure we'll talk about more in a minute, the concept of privacy by design. So at that planning stage, you've gone to your different functional leads and you understand where or why the data is going to be there, how you're collecting it, using the GDPR sort of example, the lawful basis on why you're holding that data. It might well be that actually, depending on the type, you're fully okay to have it longer than that 90 days. But the key then is knowing what it is, where it is, and why it's there.
Right, exactly, because there's also other regulations and laws that require you to actually keep data for a certain period of time, and oftentimes longer than you need it. So I just want to dig into that a little bit there. Practically, how does this work? When you're a business, a big multinational corporation, let's say, that's processing whatever petabytes that we could call it of sensitive data on a daily basis, you obviously can't look at each data point and so on. How do you actually approach this situation?
So typically you can approach it either manually or automation. You know, there's so many different companies out there that you can look to automate, particularly around the security aspect as well, and experts like yourselves. The other thing is very much investing in your teams of experts to be able to then be responsible of it. And you're doing that at the design stage before that data is even put there. That's not a fix-all, because I'm very much, advising this, and I'm hearing and seeing so many different companies still getting that wrong, but that's the ideal aspect. And that's really what I mean by the cost of compliance and the toll that that's taking, because then you also have the risks that businesses will then take because they don't think that it's going to be enforced necessarily, or if it's going to be enforced, it's going to be in the larger companies like the Metas and the Googles, and therefore you can take that risk. But the best practice would obviously be to have that resource available to then have that human control aspect, even if you do have the automated tool. And I know AI is a different topic in itself, but having the human control and oversight over that automation. And actually, I asked John Edwards, our information commissioner, recently what he would like to see in his wake in terms of enforcement and things like that. And he said, well, I'd like it to be bigger and quicker. So at the moment, we have seen that general trend that allows businesses to have a little bit of a flex on risk. But I think in the future that will come down, if you like, either through the supply chain or whichever. And that will mean that these businesses do need to probably have that combination of automation and human oversight, which means investment into your people.
Interesting. Krista, you seeing something similar?
Yes, I am a firm believer in data minimization. So all data has to have a retention period, whether it's if we keep it for this long or we keep it for this long, after, for example, someone's left employment, but there is no retention for, yes, we're going to keep this because I just might need it later. right?
Yeah.
So there isn't, oh, I'm just going to keep this because I might need it, or I'm just going to stuff it in this Google Drive and leave it there until I want to look at it later. So the implications for having too much information is if you have a data breach, say you're hacked, and I've had this happen with a client, full on ransomware, you actually don't know what you have sitting in your little Google drives. They didn't know what they had because a lot of it was really old and no one had looked at it for ages. But the other point about having too much, collecting too much data is if you get a subject access request, you have to go through everything that you have, right? So I've just had this really big subject access request come in. So they want communications between, there's about 11 or 12 named people over 5 years, right? So they would have kept 5 years worth of stuff. But then they've got 7 different variations of this person's name because they never made sure that they were using the person's accurate name. So there's like 11 people times 5 years times 7 different names. And if they'd actually gone through and did an exercise to minimize the amount of information they have, then this SAR isn't going to be as expensive or time consuming as it is now.
Right. So even the concept of minimization as a principle applies to some of these more compliance tick boxes, so to speak, that might come along with this, for example, subject access requests.
Yeah, people go, yes, yeah, we do, we do data minimization, but it's not a tick box exercise. They actually have to delete the emails, delete the files that they don't want, actually have a retention schedule and apply it. There's no point just having this thing and stuffing it in the drawer and then not doing anything about it. You may as well not have it at all.
And Christy, I know the audience are looking to get some useful tips and so on. Although the disclaimer, we're not here to give legal advice. But could you tell us? You talked about, you said, for example, when an employee is no longer working for the organization, maybe then the data should be deleted. How do companies? Is it for the organization to decide what the retention period should be? Is there anywhere they could find examples of what retention periods look like in terms of how long to keep data for?
Yeah, there's loads of things in the UK. So for example, you start with your statutory retention periods. So right to work documents are kept for 2 years after after termination, right? And then they're destroyed. Financial records like pay slips and things like that for the employee are essentially 7, so 6 plus the current financial. So they keep them for that. But if people Google HR retention schedules, there are loads of examples on the internet that will give them some idea of how long to keep the information for. Like example, working time directive things, maternity request, annual leave, all that sort of thing. There's loads of stuff on the internet.
Okay. And Sarah, have you seen, Christy mentioned, it seems to be applying an upfront exercise to figure out what's out there, and then obviously some ongoing automation and putting it into day-to-day processes. What does an exercise like this look like? Does it bring senior stakeholders together and say, where's data going? Is it like an Excel spreadsheet? How do you approach like an exercise to think about how to improve these types of processes?
So the first thing I would look at is the policy on the guidance. So the really high level bird's eye view, and that's more of the principles. And then the next level is more of the frameworks. So whether that's an AIRMF or ISO is another sort of favorite of mine. So applying that then to retention periods, you would then have, and you should be looking to your DPO to draft data retention policies that should then cover and itemize these retention periods. And then, of course, you've got the next technical level of that is, so you've had something triggered and you want it deleted. How do you ensure, or what's your control of accuracy that is actually then deleted. You know, and I'm sure you definitely come across this in security. The data that you have obviously has to be secure, but then when you do need to get rid of it, how do you ensure that it's adequately, it's not just pseudonymized or something like that? And then you've got the challenge of what constitutes that personal identifiable information or personal information in that jurisdiction, as well as then your indirect data, for example, in the GDPR. So directly or indirectly identifiable can also be a real challenge if you delete and then you have something new into the data set and all of a sudden it can be identified again. So the practical challenges of that mean that it cannot be somebody like me writing a policy and saying, crack on, boys, there you go. It needs to be very much a live, living document. So yes, I can write the guidance, and then the guys and gals will get together and make it come alive and actually run it on the technical level. So even at the legislative, we just talked about how it's the principle and it's not prescriptive. I think, in my opinion, that's a good thing because it allows things to be more agile. It allows the technical people then to actually apply and run with it. And you don't have somebody like me trying to, dictate what should go on at the technical level. However, we obviously need to be talking to each other. And I think that is going to be an increasing trend going forward more than ever before.
Wow, that's super insightful. Christy, if you could just add on what it seems companies that are doing this well, you think, this complicated world, what sort of particular parts of what they're doing well stand out to you?
I think it's the companies who've actually sat down, looked at the data that they have, right, applied any statutory retention periods, but the other data will follow a business need, right? So that comes into a lot of things like marketing. So how often are we going to send emails to these people? When are we going to delete these people off of our database? And that tends to be on the product life cycle, right? So if it's a cheap and cheerful type product, you might keep them on your database. I don't know. They don't open them for a year. Boom. Okay, we'll take that person off. I had this one client, and they sold mattresses, right? So they believe that everybody should change their mattress every 7 years. So they would keep people on the database, and at year 6.5, remind you that in 6 months' time, you need to get a new mattress because that was their product life cycle. So while there are the statutory retention periods, the law is agile in that it's not prescriptive because it can't tell each business what its business needs are and how long they should keep the information for. But it has to be justified. It can't be, I just want to keep it because I might need it at some point.
Right. So meaningful justification, just material justification. Yeah. I like that. I like the mattress example as well. And now at least I know, Christy, when I get an email from my mattress company that it's okay. Okay, so changing the topic. So I want to talk about data as a strategic asset. So as I think it's been clear to all of us and everyone who's watching, these things are hard. They're not easy. They're complicated. Does complying with these regulations give businesses a competitive advantage, or are companies just doing this to tick the box to do their job? Who wants to pick up that one?
Oh, can I pick that up?
Sure.
Yeah, I think that it does make it makes a difference to people. All right. So I can't stand cookies being dropped on my device without my consent. And if I go onto someone's website, and there's some news sites that are notorious for this, if they make me tick through, say, 1,500 vendors where I have to go turn off all the legitimate interests, then I am not going to engage with that company because they're flouting the law and they're not listening to people, right? So I think that if an organization complies with the laws, they've got a proper cookie pop-up, they've got a transparent privacy notice, then people are going to choose that company over one that has a terrible cookie pop-up, no privacy information. I've seen some like non-existent emails, for handling data inquiries. people, I mean, the GDPR has been around for a long time, so people understand more about data protection law now than they did back in 2018. And the organizations that get it right are the ones that people are going to choose over the ones that aren't doing it right.
That's super interesting. And Sarah, I mean, I said GDPR went live in 2018. It wasn't a guess. I also one of you that are passionate about this this area for sure. I would love to hear, Sarah, have you seen this? So this regulations, complying as a competitive advantage. When GDPR came about, so to speak, there was a lot of people that suggested that it would be a competitive advantage and that it would be this idea of building trust and so on. And then there was a very different approach to ticking these boxes. Over time, have you seen this change in terms of the attitude of complying being competitive advantage versus let's just get the job done?
A little bit, because I think on the global stage, there's also a bit of irritation at things like the cookie pop-ups and things like that, because the consumers or the data subjects want a convenience as well as that expectation that their rights are protected. And there is an expectation, and the beauty of data protection for me is that it's not just professional, but it's private too. As a parent, you are now very much aware of your children's privacy and these concepts and things like that. So you want the convenience, but the expectation is there also. So I don't know it necessarily gives a competitive advantage anymore because there is that expectation. Right. However, it probably does in practice because there is so much screening now for these larger sort of companies and things like that. So the transparency in the supply chain and requirements like that you are going to be more successful inevitably if you can pass those questionnaires. The other concern though would be that it falls subject then to privacy washing. So right. Saying that you're doing something and then actually under the hood, that's not the case, which has also been a trend. But I think again, with the journey that we're on, that will probably start to reduce as we see these enforcement and regulatory authorities bear more teeth.
Right. I mean, there's I wanted to ask about this because we saw a recent study in the US, for example, that showed that 79% of respondents said they are very or somewhat concerned about how companies are using the data they have collected about them. How do companies allay these fears? Because obviously a large part of data protection is in the background and behind the scenes. So is there any way other than the cookie pop-ups, which probably only a select few people can identify the problems with it like Christy has today, how can they allay fears by showing that they are compliant?
So again, it's more of the transparency. The trouble that we've had in previously is that the general public or the data users haven't been either interested or necessarily educated in these issues. That's changing. I think people really are aware. And to your point, there's a much higher percentage now. So it actually becomes easier if you have a high transparency, either through your notice or you're able to then answer the questions, then it helps allay those fears. It's not necessarily that people have the issue in how you use their data. They just want to be informed. And then obviously the secondary really important of that is to know that it is then secure, because, it's not necessarily the use in itself. And we obviously have lawful basis of the reasons behind it. So even on the data subject side, there's quite a lot of flexibility on businesses using, whether it's legitimate interest or consent for really quite wide purposes, as long as they know and they're told and they know then that you're complying with, we talked about earlier how technical and organizational measures that are sufficient or reasonable or, these kind of standards, which does give you that flexibility, but for their own conclusion to know that you're secure, then I think that helps alleviate it significantly.
That's great. And Christy, beyond the cookie notices that work correctly and lawfully, what other little tips? You've already given some great ones. What other tips can we give to companies that want to allay these fears by showing that they are complying, showing that they are caring?
I think I'll just echo Sarah's comment that it's all about transparency. But an organization's privacy notice can't be one that they've just nipped off someone else's website, tarted up a bit, and then chucked it out as their own, right? So privacy notices have to be accurate, and they actually have to reflect the data that organization say is getting from its customers and what it is actually doing with it, who it is, who it's sharing it with, and it's got the correct legal basis. But it's also about explaining it to people in a way that they understand, right? I can't stand privacy notices that read like legal contracts. We means us, you means you. I mean, honestly, people can figure that out for themselves. So, it's all the front-facing things, right? So on your privacy notice, do you ask someone to accept it? If you do, then you don't understand the law, and I don't trust you because you don't understand the fundamental point that a notice is your legal obligation to tell people what you are doing with their information. It's not something they have to agree to. They don't even have to read it if they don't want to. It's just your legal obligation. So when I'm browsing around as a consumer, albeit quite an informed consumer, I judge organizations on their front-facing information. Because I figure if you don't get the front-facing stuff right, then what's going on behind the scenes in your little Wizard of Oz place back there is not going to be up to standard if you can't get the front-facing stuff right.
I believe the GDPR might even explicitly call out writing stuff in a way that can be understandable.
It does. Yeah, it does. Yeah, absolutely. But so many organizations just think that the privacy notice has to read like a legal agreement, and the more complex they make it, the better it is. And it's actually the complete opposite. It has to be easy to understand, right? And the other point about things being easy to understand is when an organization like their website is dealing with children. They then have to write the privacy notice at an age appropriate level so the child will understand it. So these SaaS platforms that offer games for children have to comply with the age appropriate design code, and that everything has to be geared down for your 7-year-old child that's playing that. I'll go on these things. I'll still see like this thing reads like a legal agreement. Yeah, go for it, little 7-year-old child. Crack on.
Right. Yeah. It's got to be adapted for that sort of situation. I want to talk about because I was thinking, I'm sure there's something out there which is using AI to summarize these privacy policies and so on. But I want to talk about just generally the era of AI, which is very new. Obviously, when GDPR was written, it didn't have this concept of things like ChatGPT in mind. Sarah, how do we ensure it's a big question again, but how do we ensure data is protected? Does the GDPR have enough in it to cover, or other regulations and standards and so on have enough in place to protect data within these new types of tooling?
Well, we have some overlap inevitably with things like your bias discrimination laws, copyright, things like that protect in a piecemeal way. But it's widely accepted that they aren't adequate in themselves, and that's why we're seeing such a rush for comprehensive AI and things like that. But the key to really knowing if the data is protected in AI is explainability. So we talked about transparency, the sort of what, but then it's the how, and that's the real challenge that I think even our best minds are struggling with, that black box mentality. How can you actually adequately look at that? So typically the answer would then be, well, you've got to have the transparency of the data input and know what data is going into that AI to then comprehensively and responsibly sort of look at that. But for the trends then that we're seeing on that is always that human oversight aspect. And that's another element of how you can then start adequately building the trust that you are requiring really from the AI model.
And how do you, Sarah, have you seen companies approach, because obviously a lot of these AI tools like ChatGPT, you can load it up in any browser. even if your work machine or your work browser and so on doesn't let you, you can use it on your phone. How have you seen companies approaching, organizations in general, training of employees in regard to the best way to use these tools and risks that they need to watch out for?
There's a bit of a scramble for it. So I'm very blessed that I normally have my CISO to the left of me and my AI sort of guru to the right of me. And, then we sort of go forward. But the best thing also is to then train on who to ask when you have the questions, have those internal controls that mean that before use of something new, there is a legal review of that contract or, the relevant person. Because if you try and educate an individual on all of these subjects, competition law, IP, data protection, AI, the individual's head's just going to explode. That's fair enough. So getting the right people then to have reviewed before then it's used, and it's a lot easier said than done in practice, because obviously these are really sexy tools that are helping people left, right, and center. So also then understanding just where those risk barriers are. So it's not that you can't use some of the tool itself necessarily, it's that you need to watch what data then goes in. So using it to prompt and then taking out the sort of sensitive, the personal, which is what we've focused here, but also the business confidential and any sort of information that you aren't trusting the tool to then deal with.
Okay, so stripping out some of the data that, if it can be, before it's inputted.
Yeah, almost utilizing that data minimization principle again.
Exactly. And Christian, one end of the spectrum, we've got do anything with these tools, free for all, leverage them, so on. On the other end, let's try and shut down the use of ChatGPT and so on. Where have you seen success happen along the spectrum and allowing these tools, which are useful for the business in terms of innovation and productivity, to be used more safely?
I'm all for AI tools. The issue that comes up is accuracy, right? So I mean, I've done some tests with ChatGPT to see kind of what it says about the GDPR and things. And to be honest, it's not accurate a lot of the time. So what you get out, your output, is only as good as the data that went into it. So when an organization is going to use an AI tool, it has to, I'm not saying that ChatGPT isn't trustworthy. Obviously, I haven't tried it on other stuff, but it doesn't come up with completely accurate information regarding GDPR and data protection legislation. So if an organization is going to use one of these, then before they go, yeah, this is like, the best thing ever, they need to go and check out what it tells them. Right. So at least do a test. You say, you ask it something, and then you go have a look on Google, do your own research, and to see if what it's told you is accurate before you run around and decide, yep, this is it. We're gonna use this the whole time.
Okay. That's good to know. So moving on to, we're going to go back to sort of where we sort of started, because we've talked a lot about data minimization and various things here. When we look at compliance, proactive risk mitigation, complying with this world of different types of regulations, is it enough to use tools like is it enough to do risk assessments or one-off every year and sort of take that more ad hoc approach, or should we be reviewing policies and procedures and upgrading these things more regularly? Sarah, I'd love to get your take on this.
No would be the short answer. But then equally, it doesn't mean that you need to update the policy so regularly either. The key is that the risk assessment becomes a living document. So it's regularly updated. And so typically you would do the impact assessment and then have an owner of that impact assessment who is then the center of truth, who then would update. And then that gets flagged to your relevant SME, so particularly DPO, security, or in ours, if it is an AI, our AI director, so that it you're not going that period of time where it's out of date, because I think that again increases your risk. Practically speaking, you might have to.
Christy, is the dog on the screen?
Oh God, sorry, the dog's outside actually.
It's quite okay. Maybe
Sorry, I think there was a squirrel running along the back fence.
that's quite okay. I mean, you or your dog or the squirrel could pick up the similar question, Christy. Is it enough to use tools like an annual data risk assessment, or to keep up with compliance, or reviewing procedures and upgrading them more regularly? How have you seen this work?
I think it depends on who you are and what you do, right? So I think the starting point for everybody is an audit, data protection audit. See what you've got, what you do with it, who you share it with, right? And then from, like Sarah was saying, from then on, you can go and say this needs to be looked at more often because it's more of a high risk area. And nope, this other bit here that can go once a year, or we can look at the policies once a year. But no, we've got this new system coming in, so now we're going to have to integrate it. So we're going to have to risk assess it. There's no so, you know, it's like the big legal thing. Be like, it depends. We all love to go say it depends. So it depends on what you do, what kind of data you've got, you know, and what kind of risky activity you're engaging in. Because some organizations are fairly straightforward and wouldn't need to have a data protection audit every year. Maybe every 2 years is enough for them. It just depends on who you are and what you do.
Okay, great. And you said, when we talked about, when you just mentioned then what data you have, who you share it with the implications in terms of the risk factor and so on. We haven't talked a lot about Matomic and our sort of unique area of data security management here today, but one of the things that we obviously have a lot of experience with is, particularly in SaaS applications like the Google Drives and the Slacks and the Jiras and so on, is integrating with these tools to find what sensitive data is out there. One piece of this is personal data, which we've talked a lot about today, but other things like company balance sheets and passwords and so on and so forth. Finding where this data is and also who has access, because in today's tech world, it's not just your employees that have access when they're in the office working 9 to 5. It can often be shared publicly and to people outside the organization and to the entire company. What have we seen work in terms of, or resources that organizations can be using to take a more proactive approach to risk mitigation, which, to Christy's point, probably starts with what data do we have, who we share it with, how risky it is, and so on. Is there any helpful tips we can give the audience there?
Which one of us did you want to pop in on this?
What do you think, Sarah?
I would say that there's a myriad of things that you can do. Obviously, we've talked about people, excuse me, really suffering with the sort of winter cold still. But the problem with people, as you can probably hear, is that they're obviously not only biased and can have their limitations and things like that. But they're also then limited in terms of resource and can be more costly. So working with external experts that deal with this every day can often then be a really useful secondary resource as well. You've got somebody who's dedicated to the area of complexity. Okay.
Christy, taking a proactive approach to risk mitigation, and to your point, what data you have, who you share it with, figuring out the basics relates to data minimization, which you talked about. Any tips, tricks, suggestions on how this can be approached and resources that can be used?
I think it's essentially sitting down and going, we've got this data, but having an access register. So what do we have? Where is it? And who has access to it? But it's also, because you mentioned WhatsApp groups and Slack, right? So the data that's held in those will also form that company's data and part of a subject access request, including what, like kind of off-grid WhatsApp groups, right? Say the HR team's got this WhatsApp group going on between the 5 of them, but it's not a company sanctioned group. when it comes down to the subject access request, that WhatsApp group is within the scope. So it's knowing everything that's out there. And sometimes companies don't go through this exercise until they're forced to, until they've got a huge subject access request, and now they have to find it. And then they go, oh my God, we didn't know we had all this. We didn't know this was here. And good God, there's a WhatsApp group running over there that we had no idea about. So I think if they did those sorts of activities before they had the whopping big subject access request or the horrible data breach, when they got one of those, it wouldn't be quite as bad.
Okay.
I think that's, in practice, that's particularly useful to then build those relationships with the different areas of the business, and then conduct a ROPA audit, so the record of processing activity, even where it's not required. So just sort of in GDPR where it's required, but even in the jurisdictions where it's not required, it's a really useful tool to build that transparency, even if it's not on the granular level, just knowing what could be where and who to speak to, and having that available. Because as we were just sort of being said there, when you do have some of these big requests or even a data breach, something like that, then you're scrambling. So you can save yourself so much time, because we do have time windows as well, 24 hours, 48 hours, the 72 hours, depending on what context to then respond to these, which is incredibly tight.
And just adding on to that, so we talked before about how the companies show proactively that they care, that they're complying, and you're talking there about something like a ROPA, which often obviously isn't shared with customers and is probably more behind the scenes. But what we see is that companies that do take a very authentic and genuine approach to these things and they care about them, it ends up manifesting to the end customer at the end of the day. Firstly, they have less likelihood of, for example, a data breach, because they're putting in the right controls and processes to minimize that risk. But when they install this culture, they make it important, it ends up manifesting to the end data subject or consumer that the company cares about data privacy, data protection, they care about customer trust, and so on. So all this stuff that goes on does help the business build this trust at the end of the day, even though it might not seem it from the outset.
Absolutely. And that trust starts with being able to trust within your team.
Right.
So I need to trust my CISO that I can go to him and say, is this secure? And that he's kept up to date with the sort of latest, whatever it is, and that he can give me that review, rather than one person thinking that they can do all of it. So the team trust to then build that customer data subject trust, transparency, and all the rest of it. And I guess then it's not just looking at the regulatory level, but you're actually looking at the ESG, that social level responsibility, social corporate responsibility of actually going up what's right, not just what's legal, what do I have to do, what's the right thing to do.
Right, exactly. Okay, so we've got 7 minutes left and we've got a few questions, Q&A to get through here. So gonna go through with the questions that we've got. Thank you for submitting them before and during today's talk. Gonna go one by one and sort of direct them. So we'll start off with a question about WhatsApp. Christy, you mentioned it, so I'll hand this one to you. The question is, WhatsApp groups on personal devices that aren't agreed by the organization, are they in scope for SAR, which I would assume means subject access request, and how would an organization know that they exist?
Yes, they are in scope. Normally, I've had one of these where the organization didn't know that this off-grid WhatsApp group was going on until one of the people in the group became so offended at the things they were saying about other people in the company that she went to HR, right? So the law is ever expanding on what type of devices are included. So personal devices are included because a lot of companies don't provide work devices. And if personal devices weren't included, then nobody would provide a work device, because they would just go, well, personal devices aren't included, so we're going to have all personal devices. So to answer that question is, yes, personal devices are included. Business conversations on personal devices are included within the scope as well. And how they find out is that someone will usually tell the business.
Okay.
Someone will complain about something at some point.
Wow, that's a tough one to deal with for sure. But thank you for giving that advice and the tip there. Sarah, this is another question that was submitted before today's talk. How can businesses strike a balance between collecting and analyzing customer data for insights whilst respecting individual privacy rights and preferences?
Look at the need itself. And then seek to strike that balance. It is okay to process that personal information if you have the right controls and basis to do so. So if you start with that need and then build around it, that's how you're going to find your balance.
Right, again, so we come back to the need, the genuine need, not the, as Christy's been saying to us, not the keep it because it might be useful in the future for insights. Exactly. Okay. One final question. So Christy, I'll give this one to you. How can data protection laws be integrated into our product development lifecycle to ensure that privacy and security are embedded from the outset rather than treated as an afterthought?
Oh, well, that's easy to answer, is start at the beginning, right? So I worked with a lot of SaaS companies, and one of them, bless them, is notorious for going, oh, look, we've created this new shiny thing. Then they'll present it to me and go, oh, what do you think of this? And I think, oh God, you should have told me at the beginning, because now I've got to go and pick it apart and put the data protection in here and the data protection bit in there. It's far cheaper and more efficient to embed your data protection bits at the beginning than create your shiny new thing and then go, oh, where are we going to put that data protection bit now?
Okay, yeah. So always at the outset, think about these things ahead of time, not leave it as an afterthought as the question asked. Okay, we're out of time. So firstly, I want to extend a really warm thank you to both Sarah and Christy for your time today. Really appreciate it. That's been a very insightful conversation for me and hopefully for the audience as well. And so to the audience, thank you for your time. Recordings will be sent out after today's session. And I think it's good to remember that compliance is a byproduct of good data security practices in the first place. At Atomic, we're helping customers attain compliance or help attain compliance with industry regulations by ensuring they're minimizing the risks to their sensitive data, as we've talked a lot about today. Just to reiterate, each business should obviously seek individual advice when it comes to complying with regulations relevant to their organization. But I'm going to leave us all there. Thank you so much to Sarah and to Christy's dog for joining us.
My dog's just kicked off.
Okay, thank you all. Bye.
Thank you.
Thank you.